Members of the jury, I thank you for your attention during this trial. Please pay attention to the instructions I am about to give you. You will get a hard copy of these instructions. Feel free to take notes if you want. Feel free not to take notes, but you will get a hard copy, just so you guys know. Johnathan Quiles, the defendant in this case, has been accused of the crimes of 2 counts of murder in the first degree and 1 count of sexual battery. Johnathan Quiles is accused of first-degree murder in counts 1 and 2. First-degree murder includes the lesser crimes of second-degree murder and manslaughter, all of which are unlawful. However, a killing that was excusable or that was committed by the justifiable use of deadly force is lawful. If you find IS as to count 1 and or the unborn child of IS as to count 2 was killed by Johnathan Quiles, you will then consider the circumstances surrounding the killing and deciding if the killing was first-degree murder or second-degree murder or manslaughter, or whether the killing was excusable or resulted from justifiable use of deadly force. The killing of a human being is justifiable homicide and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in any dwelling house in which the defendant was at the time of the killing. The killing of a human being is excusable and therefore lawful under any of the following circumstances. 1. When the killing is committed by accident and misfortune in doing any lawful act by lawful means with the usual ordinary caution and without any lawful intent. Or 2. When the killing occurs by accident and misfortune in the heat of passion upon any sudden insufficient provocation. Or 3. When the killing is committed by accident and misfortune resulting from a sudden combat, if a dangerous weapon is not used, and the killing is not done in a cruel or unusual manner. A dangerous weapon is any object that will likely cause death or great bodily harm if used in the ordinary and usual manner contemplated by its design and construction. An object not designed to inflict bodily harm may nonetheless be a dangerous weapon if it was used in a manner likely to cause death or great bodily harm. Great bodily harm means great, as distinguished from slight, trivial, minor, or moderate harm, and as such does not include mere bruises. I now instruct you on the circumstances that must be proved before Johnathan Quiles will be found guilty of first-degree murder or any lesser included crime. As to count 1, to prove the crime of first-degree premeditated murder, the state must prove the following 3 elements beyond a reasonable doubt. 1. IS is dead. 2. The death was caused by the criminal act of Johnathan Quiles. 3. There was a premeditated killing of IS. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. Killing with premeditation is killing after consciously deciding to do so. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. The question of premeditation is a question of fact to be determined by you from the evidence. It will be sufficient proof of premeditation if the circumstances of the killing and the conduct of the accused convince you beyond a reasonable doubt of the existence of premeditation at the time of the killing. If you find that Johnathan Quiles committed first-degree murder, and you also find beyond a reasonable doubt that during the commission of the crime, he discharged a firearm, and in doing so caused great bodily harm to, or the death of IS, you should find the defendant guilty of first-degree murder with discharge of a firearm causing great bodily harm or death. Great bodily harm means great, as distinguished from slight, trivial, minor, or moderate harm, and does not include mere bruises. If you find that Johnathan Quiles committed first-degree murder, and you also find beyond a reasonable doubt that during the commission of the crime he discharged a firearm, you should find the defendant guilty of first-degree murder with discharge of a firearm. If you find that Johnathan Quiles committed first-degree murder, and you also find beyond a reasonable doubt that during the commission of the crime he actually possessed a firearm, you should find the defendant guilty of first-degree murder with actual possession of a firearm. A firearm is legally defined as any weapon, including a starter gun, which is designed to, or may readily be converted to expel a projectile by the action of an explosive, the frame or receiver of any such weapon, any firearm muffler or firearm silencer, any destructive device, or any machine gun. To actually possess a firearm means that the defendant, A, carried a firearm on his person, or B, had a firearm within immediate physical reach with ready access, with the intent to use the firearm during the commission of the crime. As to count 2, to prove the crime of first-degree premeditated murder, the state must prove the following 3 elements beyond a reasonable doubt. 1. The unborn child of IS is dead. 2. The death was caused by the criminal act of Johnathan Quiles. 3. There was a premeditated killing of the unborn child of IS. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. Killing with premeditation was previously defined for you. The question of premeditation is a question of fact to be determined by you from the evidence. It will be sufficient proof of premeditation if the circumstances of the killing and the conduct of the accused convince you beyond a reasonable doubt of the existence of premeditation at the time of the killing. If you find that Johnathan Quiles committed first-degree murder, and you also find beyond a reasonable doubt that during the commission of the crime he discharged a firearm, and in doing so caused great bodily harm to or the death of the unborn child of IS, you should find the defendant guilty of first-degree murder, discharge of a firearm causing great bodily harm or death. Great bodily harm has previously been defined for you. If you find that Johnathan Quiles committed first-degree murder, and you also find beyond a reasonable doubt that during the commission of the crime he discharged a firearm, you should find him guilty of first-degree murder with discharge of a firearm. If you find that Johnathan Quiles guilty of first-degree murder, if you find that Johnathan Quiles committed first-degree murder, and you also find beyond a reasonable doubt that during the commission of the crime he actually possessed a firearm, you should find the defendant guilty of first-degree murder with actual possession of a firearm. Firearm has previously been defined for you. To actually possess a firearm has previously been defined for you. In considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the main crime of which he is accused, there may be evidence that he committed other acts that would constitute a lesser included crime. Therefore, if you decide that the main accusation has not been proven beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser included crime. The lesser crimes indicated in the definition of first-degree murder are as follows: second-degree murder, manslaughter. The instructions for second-degree murder and manslaughter as lesser included crimes for first-degree murder are combined into one instruction for simplicity purposes. The only difference is the name of the victim in the elements of the crimes. As to count 2, to prove the lesser included crime of As to counts 1 and 2, to prove the lesser included crime of second-degree murder, the state must prove the following 3 elements beyond a reasonable doubt. As to count 1, IS is dead. As to count 2, the unborn child of IS is dead. Element 2, the death was caused by the criminal act of Johnathan Quiles. Element 3, as to count 1, there was an unlawful killing of IS by an act imminently dangerous to another in demonstrating a depraved mind without regard for human life. As to count 2, there was an unlawful killing of the unborn child of IS by an act imminently dangerous to another in demonstrating a depraved mind without regard for human life. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. An act is eminently dangerous to another in demonstrating a depraved mind if it is an act or series of acts that 1. A person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another, and is done from ill will, hatred, spite, or an evil intent, and is of such a nature that the act itself indicates an indifference to human life. In order to convict of second-degree murder, it is not necessary for the state to prove the defendant had the intent to cause death. If you find that Johnathan Quiles committed second-degree murder, and you also find beyond a reasonable doubt that during the commission of the crime he discharged a firearm, and in doing so caused great bodily harm to or the death of IS as to count 1, and or the unborn child of IS as to count 2, you should find the defendant guilty of second-degree murder with discharge of a firearm causing great bodily harm or death. Great bodily harm has previously been defined for you. If you find that Johnathan Quiles committed second-degree murder, and you also find beyond a reasonable doubt that during the commission of the crime he discharged a firearm, you should find the defendant guilty of second-degree murder with discharge of a firearm. If you find that Johnathan Quiles committed second-degree murder, and you also find beyond a reasonable doubt that during the commission of the crime he actually possessed a firearm, you should find the defendant guilty of second-degree murder with actual possession of a firearm. Firearm has previously been defined for you. To actually possess a firearm has previously been defined for you. As to counts 1 and 2, to prove the lesser included crime of manslaughter, the state must prove the following two elements beyond a reasonable doubt. Element 1, as to count 1, IS is dead. As to count 2, the unborn child of IS is dead. Element 2, as to count 1, Johnathan Quiles intentionally committed an act or acts that caused the death of IS. As to count 2, Johnathan Quiles intentionally committed an act or acts that caused the death of the unborn child of IS. Every person has a duty to act reasonably towards others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. The defendant cannot be guilty of manslaughter by committing a merely negligent act, or if the killing was either justifiable or excusable homicide, as been previously defined to you. In order to convict of manslaughter by act, it is not necessary for the state to prove that the defendant had an intent to cause death. Only an intent to commit an act that was not merely negligent, justified, or excusable, and which caused death. If you find that Johnathan Quiles committed manslaughter, and you also find beyond a reasonable doubt that during the commission of the crime, he personally carried, displayed, used, threatened to use, or attempted to use a firearm, you should find him guilty of manslaughter with a firearm. Firearm has previously been defined for you. If you find that Johnathan Quiles committed manslaughter, or you are not convinced beyond a reasonable doubt that he personally carried, displayed, used, threatened to use, or attempted to use a firearm, then you should find him guilty only of manslaughter. As to count 3, to prove the crime of engaging in an act that constitutes sexual battery upon or with a child 12 years of age or older, but younger than 18 years of age by a person in a familial or custodial authority, the state must prove the following 3 elements beyond a reasonable doubt. 1, Johnathan Quiles engaged in any act that constitutes sexual battery. 2, at the time, IS was 12 years of age or older, but younger than 18 years of age. 3, at the time, Johnathan Quiles was in a position of familial or custodial authority to IS. Sexual battery means the sexual organ of Johnathan Quiles penetrated or had union with the female genitals of IS. Ignorance of IS's age, IS's misrepresentation of her age, or the defendant's bona fide belief of IS's age is not a defense to the crime charged. Bona fide means genuine. It is not a defense that IS was willing or consented to engage in an act that constitutes sexual battery. IS's lack of chastity is not a defense to the crime charged. An object includes a finger. Union means contact. Female genitals includes the labia minora, labia majora, clitoris, vulva, hymen, and vagina. As to counts 1 and 2, the state must prove the crimes were committed on or between December 19 and December 20, 2018. As to count 3, the state must prove that the crime was committed on or between December 1, 2017 and December 20, 2018. It must be proved only to a reasonable certainty that the alleged crimes were committed in Duval County. The defendant has entered a plea of not guilty. This means you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation in the indictment through each stage of the trial, unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed, and the defendant is the person who committed the crime. The defendant is not required to present evidence or prove anything. Whenever the words reasonable doubt are used, you must consider the following. A reasonable doubt is not a mere possible doubt, speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if, after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial and to it alone that you are to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or the lack of evidence. If you have a reasonable doubt, you should find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. During the course of this trial, you heard testimony from SS and ID. The testimony from SS regarding other crimes, wrongs, or acts allegedly committed by the defendant shall be considered by you only as that evidence relates to motive, opportunity, intent, plan, absence of mistake or accident, or corroboration of IS as it relates to count 3. The testimony shall not be considered as to motive as to counts 1 and 2. The testimony from ID regarding other crimes, wrongs, or acts allegedly committed by the defendant shall be considered by you only as that evidence relates to motive, opportunity, intent, plan, or absence of mistake or accident. The testimony shall be considered as to motive as to counts 1 and 2. However, the defendant cannot be convicted for a crime, wrong, or act that is not included in the indictment. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are: did the witness seem to have an opportunity to see and know the things about which the witness testified? Did the witness seem to have an accurate memory? Was the witness honest and straightforward in answering the attorney's questions? Did the witness have some interest in how the case should be decided? Does the witness's testimony agree with the other testimony and other evidence in this case? Has the witness been offered or received any money, preferred treatment, or other benefit in order to get the witness to testify? Had any pressure or threat been used against the witness that affected the truth of the witness's testimony? Did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? Has the witness been convicted of a felony or misdemeanor involving dishonesty or a false statement? Whether the state has met its burden of proof does not depend upon the number of witnesses it has called or upon the number of exhibits it has offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses with one exception. The law permits an expert witness to give his or her opinion. However, an expert's opinion is reliable only when given on a subject about which you believe him or her to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. You must consider the testimony of some witnesses with more caution than others. For example, a witness who hopes to gain more favorable treatment in his own case may have a reason to make a false statement in order to strike a good bargain with the state. This is particularly true when there is no other evidence tending to agree with what the witness says about the defendant. So while a witness of that kind may be entirely truthful when testifying, you should consider his or her testimony with more caution than the testimony of other witnesses. However, if the testimony of such witness convinces you beyond a reasonable doubt of the defendant's guilt, or the other evidence in the case does so, then you should find the defendant guilty. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his or her testimony. You may rely upon your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. The Constitution requires the state to prove its accusation against the defendant. It is not necessary for the defendant to disprove anything, nor is the defendant required to prove his innocence. It is up to the state to prove the defendant's guilt by evidence. The defendant exercised a fundamental right by choosing not to be a witness in this case. You must not view this as an admission of guilt or be influenced in any way by his decision. No juror should ever be concerned that the defendant did or did not take the witness stand or to give testimony in the case. A statement claimed to have been made by the defendant outside of court has been placed before you. Such a statement should always be considered with caution and be weighed with great care to make certain it was freely and voluntarily made. Therefore, you must determine from the evidence that the defendant's alleged statement was knowingly, voluntarily, and freely made. In making this determination, you should consider the total circumstances, including but not limited to whether when the defendant made the statement he had been threatened in order to get him to make it, and whether anyone had promised him anything in order to get him to make it. If you conclude the defendant's out-of-court statement was not freely and voluntarily made, you should disregard it. There are some general rules that apply to your discussion. You must follow these rules in order to return a lawful verdict. 1. You must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. This case must be decided only upon the evidence that you have heard from the testimony of the witnesses and have seen in the form of the exhibits and evidence and these instructions. This case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. Remember, the lawyers are not on trial. Your feelings about them should not influence your decision in this case. Your duty is to determine if the defendant has been proven guilty or not, in accord with the law. Whatever verdict you render must be unanimous, that is, each juror must agree to the same verdict. Your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and on the law contained in these instructions. Deciding a verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything I may have said or done that made you think I preferred one verdict over another. You may find the defendant guilty as charged or guilty of such lesser included crimes as the evidence may justify, or not guilty. If you return a verdict of guilty, it should be for the highest offense on the verdict form for each count that has been proven beyond a reasonable doubt. If you find that no offense has been proven beyond a reasonable doubt, then of course your verdict must be not guilty. The verdict must be unanimous. That is, all of you must agree to the same verdict. Only one verdict may be returned as to each crime charged. The verdict must be in writing, and for your convenience, the necessary verdict forms have been prepared for you. They are as follows. So there's 3 verdict forms. One for count 1, one for count 2, one for count 3. I'm holding them in my hand. I'm going to go over the one for count 1 for you so you understand how it works. It's difficult for you to see, but once you see it in person, in front of you, it'll make more sense. The top line up here reads, "We, the jury, find the defendant guilty of first-degree murder as charged in the indictment." If that's your verdict, you check that box. Then you make a further finding regarding the fire that was discussed in the instructions. On the second page is the lesser included charges of second-degree murder or manslaughter and the further findings. Then the last one you have is you find him not guilty. You only check one of the boxes on the far left. First-degree murder, second-degree murder, manslaughter, or not guilty, based off the law that I've read to you. If your verdict requires a further finding, then you go to the indented part of that request. And then the foreperson would sign and date it. Count 2 acts very similar, except it's a different victim, the unborn child of IS. For count 3, it's very simple. He's guilty of the crime charged or not guilty, and you sign and date it. There's no further finding on that one. A separate crime is charged in each count of the indictment, and although they have been tried together, each crime and the evidence applicable to it must be considered separately and a separate verdict returned as to each. A finding of guilty or not guilty as to one crime must not affect your verdict as to the other crimes charged. In just a few moments, you'll be taken to the jury room by the bailiff. The first thing you should do is choose a foreperson who will preside over your deliberations. The foreperson should see to it that your discussions are carried on in an organized way and that everyone has a fair chance to be heard. It is also the foreperson's job to sign and date the verdict form when all of you have agreed on a verdict and to bring the verdict form back to the courtroom when you return. The foreperson will have the forms, fold them in half, give them to Mr. Gray or the bailiff, and then he'll give them to me. During deliberations, jurors must communicate about the case only with one another and only when all jurors are present in the jury room. You are not to communicate with any person outside the jury about this case. Until you have reached a verdict, you must not talk about this case in person or through the telephone, writing, electronic communication, blogging, Twitter, email, text, etc. Do not contact anyone to assist you during deliberations. These communication rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any other instruction I have given in this case, you must tell me by giving a note to the bailiff. Many of you have cell phones, tablets, laptops, other electronic devices here in the courtroom. The rules do not allow you to bring your phones or these devices into the jury room. Mr. Gray and the bailiffs will collect them from you, and they'll hold custody of them until the end. If you need to communicate with me, send a note through the bailiff signed by the foreperson. If you have voted, do not disclose the actual vote on the note. If you have questions, I will talk with the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any questions if I can in writing or orally here in open court. During the trial, items were received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations. These exhibits will be sent into the jury room with you when you begin to deliberate. If you notice in the jury room, there's a monitor on the wall. It's not a TV screen. It's actually, well, it has no access to anything, internet, etc. It's just a big, essentially big computer monitor. The staff will set it up for you, turn it on for you. If you have any issues with that, let me know. It should have been checked out already. And they'll set you up to where you can put CDs in there, listen, view anything that you guys wish to do throughout the trial. That way you can all see it at one time versus a small computer screen. In closing, let me remind you that it is important that you follow the law spelled out in these instructions in deciding your verdict. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For 2 centuries, we have lived by the Constitution and the law. No juror has the right to violate rules we all share. So in a couple minutes, the bailiffs will take you back to the jury room. I talked about scheduling. So you guys will begin your deliberations here in a moment. We will wait to hear from you on anything. I need to know by 6 if you guys want dinner. We will order you pizza if that's what you want. If at a certain time you guys want to break for the day and come back tomorrow, you just let us know when, and we will abide by your wishes as a collective group. Juror numbers 73, 75, 86, and 89. To break it to you, you 4 were our alternate jurors this week, which means that I cannot let you back in the jury room with the other 12. However, can't officially dismiss you yet. What I'm going to do is go ahead and have the other. Do you guys have any personal belongings in the room? You guys do? Okay. What I'm going to do is, if you guys don't mind, go and get those personal belongings, and you'll come back out. and then I'll read you guys some additional instructions. Okay, so to the 4 alternate jurors, I have some additional instructions I need to read to you guys. This is specific to you guys, although it kind of applies to everybody. As you guys have already told you, I can't let the 4 of you into the jury room with the other 12 at this point. The law does not allow me to do so. However, I do not know if there's going to be another phase to this trial, as we discussed during jury selection. What I'm going to do at this time is excuse you from the courtroom and remind you that you are still remain under the order this court not to have any discussions with anyone concerning this case, not to read or listen to any reports about this case. Because if the second phase is necessary, I am going to be asking you to return to participate in that second phase of the trial. The reason why we have alternates is because, especially in the cases that last, the length that we're here for, emergencies arise, acute issues arise. And if that's the case, the alternates have to step in. Fortunately, everyone's remained happy and everyone's remained healthy in here, so we haven't had the need for an alternate to step in. However, that need may arise next week if we go to a second phase. I don't know that right now, which is why ordinarily I would dismiss the alternates and say you're free to do whatever you want. I can't do that yet. You still have to remain under order of the court not to discuss the case like you have the past 2 weeks. However, I just can't let you deliberate with the other 12 right now. So I don't know if we go to a second phase, I don't know when that's going to occur. We have your phone numbers, and we will call you and let you know next. Someone will call you either way. I'll let you guys know either way, because if you're not needed and you're dismissed, I want you guys to know that as well. But again, I remind you that you remain under order of the court not to discuss the case with anyone and not to read or listen to any reports about the case. No one is allowed to contact you concerning this case. At this time, I thank you very much. I'm very happy that the 12 have been able to remain here the past week and a half. And you're technically still a member of the jury and still under direction of the courts. Your notes have been collected. We're going to keep them because if you need them later on, we're going to obviously give them back to you. So I officially thank you. I have your numbers. And as soon as we know something, I'll certainly give you guys a heads up and notify you as well as to what the next step is. So I'll talk to you guys soon. Okay, so to the 12 of you, you guys will now be taken back to the jury room here in a moment. The clerk will collect all the evidence and the jury instructions and the verdict forms and bring them to you. Mr. Gray will collect your devices that we talked about. And given the instructions I mentioned earlier, we'll wait to hear from you. You can officially bring your notes with you. Oh, I'm sorry. One thing. I failed to mention this. So we have a firearm and we have ammunition. I can't give them both to you at the same time. I'll give you the firearm. If you wish to switch, let the bailiffs know. jury's outside our presence. You guys may have a seat. I still have counsel for the state defense and Mr. Quiles present. Any exception or objection to the jury instructions as read to the jury? First from the state defense. There were a couple typos I want to fix on the jury instructions. Nothing major. I read it correctly to the jury. I just want the paperwork to reflect what I read. There was a couple, yes. Yes. So I'm going to fix that before we go back. Okay, I'm getting a clean copy. Otherwise, is there anything else we need to handle outside the jury's presence? First from the state defense. Okay, the jury will be provided the instructions, the verdict forms, and the evidence, and just we'll wait to hear from them. They've been clear instructions about how we're going to proceed tonight. So the ball's in their court. So we're in recess.